Okay, so paragraph 5, broker services to others. This is where basically it explains that obviously we work with other clients at the same time. We may even end up showing that same house to a different buyer. We may possibly end up writing an offer on the same house for another buyer. If there's any kind of conflict of interest as far as, let me try to think of a good idea here. I mean, if you can't, if something comes up in the situation where you have two buyers interested in the same home, and something comes up that you need to disclose to both, but for some reason there's a conflict there. Like, I can't think of a good example off the top of my head, but you would get me involved so that I can kind of help let both people know what they need to know without it being a conflict from you.
Okay.
Does that make sense? Okay. 6, this is a contract in its entirety. All changes must be made in writing and signed by all parties. Transfer of the contract. The buyer agrees that, like if our broker stopped doing business, or heaven forbid something happened to you and you could no longer represent them, our broker would like the first opportunity to match them up with another agent.
Okay.
However, ultimately, it really is the buyer's decision. Confidentiality, number 8, is obviously very important. We, unless permitted by the buyer, will not disclose any of their personal information to anybody for any reason. However, once we're under contract, there is something that they'll sign saying that we can communicate, with the title company and the lender and so on and so forth. Expertise of real estate agents. So this boiled down basically is stating that if there's something that is outside of the scope of what we're licensed to do, like, during a walkthrough, they're asking about something that looks like mold, or they have a very specific legal question, it's our job to point them in the right direction of who to talk to, like a mold remediator, a contractor, a real estate lawyer, something like that. We don't ever want to give out advice that's outside the purview of our license, because that could really come back and bite you in the butt. They could be like, well, Jamie told me that it wasn't mold. You know what I mean?
Yeah.
So, deposit money. So this part broken down is basically stating that, obviously once we're under contract and they have to turn in their earnest money deposit within 5 days to the listing broker, if they're the ones holding it, which 90% of the time they are. If they choose not to deliver it themselves to the listing broker, and we, meet them somewhere to deliver it for them as part of our service or whatever, obviously we are physically holding on to their money for a very short amount of time. But that's a pretty big deal. So, this is not only talking about that, but letting them know that, any kind of disputes, if it doesn't get to where it needs to be, or gets lost or anything like that, that everybody's going to work together to get it figured out. It also states that if they took us to court, if they name, like say the listing broker loses their EMD, which I did have that happen, but it didn't get this far. But say the listing broker lost their EMD, and the buyer took, that listing broker to court, but they also named us in litigation. whoever named us in the litigation has to cover our attorney fees. Then the Civil Rights Act is pretty self-explanatory. We cannot and will not discriminate for any reason at any time. And if you end up working with someone that is acting that way, you have every right to dissolve that contract, should you choose to do so. Notice regarding convicted sex offenders. It is the due diligence of the buyer, so not us, but the buyer, if that's important to them to know if there are sex offenders in the area that they're looking at. It states the PA Megan's Law website right there, and the buyer can go on there, plug in the address, and make sure that they're comfortable with moving forward. Then the buyer's inspections. So again, unless they are getting inspections, they're saying that I accept this property in its present condition. So that's why we always advise to get inspections. Now, obviously in this market, people are choosing to waive inspections and things like that. And if that is the situation that you find yourself in, you just need to make sure that you have really covered your behind and made sure that they realize what that could look like. You know, not that you want to scare them, but you want to let them know realistically, like, you know, maybe at least get a home warranty like that. I feel like this is a good time to bring up the home warranty. Like, you know, if they're talking about waiving inspections to win a house, maybe at least get the home warranty or something like that, just so they have a little peace of mind. But we should always be advising to get an inspection. If someone were to flat out ask you, should I waive an inspection? Your answer should always be no.
What if they want to win?
So I tell them, my exact wording is, you need to do what you feel is right. I can't tell you what to do or what not to do, but I will never tell you not to get an inspection. That's my basic wording when people say, you know, well, to be more competitive, should I waive my inspections? Like, well, you need to do what you're comfortable with, but in my professional opinion, I would never tell you not to get one.
Okay.
Because you have to be careful with any variation of that, because you don't ever want it to come across that my agent told me to waive an inspection.
Okay.
Okay, then recordings on the property. So this, basically everybody has some kind of Ring doorbell, Alexa, cameras, some kind of recording device on their properties now, right? So I tell my buyers to just expect that it's there. The listing agent is supposed to legally disclose that in the MLS so that we know going in, but honestly, it's become so commonplace now that I think that gets forgotten a lot. So I just tell my buyers, just act as though there is some kind of recording device on the property. Don't lay your cards out on the table if we walk in and you love it. Like, let's not talk specifics. Please don't talk about things you don't like while we're inside the home. And even Ring doorbells, like, you have to be probably a good 15 feet away for it to not hear you.
Yeah.
So any specifics that we're going to talk about the property, we're going to do either out at our cars or, you know, on the phone after the showing.
Okay.
Because, again, if a seller were to hear something that, you know, everybody's sue happy, that pissed them off enough that they want to sue those buyers, and again, we get named in that lawsuit, whoever named us, again, has to pay for our legal fees.
Okay.
However, it's just better safe than sorry to be like, Just, if there are things you like about the home, like it's okay to say that while we're in there. Like, oh, the tile work is beautiful. The flooring is really pretty, like things like that. But don't go too far into detail with anything.
Okay.
Especially if they're considering writing an offer. Like you were there to witness one where we were inside the house and she's like, what would you recommend I like make my offer at? And I'm like, well, let's talk outside. Like you just don't want to go too far into detail. Okay, then the recovery fund. This is on like everything. It's on your consumer notice. It's on your listing agreement. It's on the buyer agency we're going over. It's on the AOS. Basically, if we were to ever do anything to financially harm the buyer in this situation, because it's on the buyer agency, by like fraud or misrepresentation or deceitfulness, anything like that, and they take us to court, okay, and we can't pay whatever the judge says that they're owed, they literally call this number to get their judgment.
Okay.
And then the state deals with us later. That's kind of the little tagline I put at the end of it because it's really scary to some people to hear that. So like when I go over this part, I'm like, this part sounds really scary. I've never had it happen, but it's important that you know that the state of Pennsylvania is protecting you.
Okay.
Then I go over that, and then my last little thing is, don't worry, the state will deal with me later.
Okay.
And it kind of like ends it on a light note, so they don't feel as like freaked out about it. Then if there were any special terms or clauses, like, I don't know, specific things that they wanted you to do, like maybe they don't drive, and so you're agreeing to pick them up and take them to every showing, or just anything additional that's not in here that you want in writing, you're going to put in that section. Then the last portion here, again, is just going over that they've read the consumer notice, which is the very first thing we always do, that they've read this entire contract and are agreeing to it by signing. If they are obtaining mortgage financing, that the buyer will promptly deliver to us a copy of any of the like loan documents that they've gotten, pre-approvals, estimated cost sheets, anything like that.
Okay.
Because that is how we are going to then help them shop in the right price range and all of that good stuff. Return of this contract and any addenda or amendments. So even like electronic signatures, it still constitutes, like they're basically just saying that, yes, anything that's e-signed is acceptable as an actual signature.
Okay.
To put that more in like layman's terms. And this contract may be executed in one or more counterparts, each of which shall be deemed to be an original, and which counterparts together shall constitute one. Okay, so in layman's terms, again, anything that you add to this or change becomes, once it's in writing, like it said before, and everyone has signed the changes, it becomes part of this contract. Okay, so then again, it says if they have legal questions before signing, that they should consult a Pennsylvania real estate attorney.
Okay.
Sweet.